Petition. Seko Wino, the NMG head of legal, still with us, and joining us as well is Harrison Kinyanjui, a lawyer here in Nairobi. Thank you for coming in. Now, we already got Seko's take on the presidential petition, at least what NASA needs to do to solidify its case. Over 20,000 pages of evidence they submitted yesterday. What do you make of that?
20,000? 20,000? It's no more than 5,000.
In your view?
I think by saying 20,000, it's this psychic, sort of psychological weighing in on everybody else who they want to get their sympathy from. It's not 20,000 pages. They have a problem, and a big one at that. Mm-hmm. First of all, they say that 2.6% of the votes are spoiled, and that they should count in the aggregate tally of the presidential votes. Now, they have a problem because in 2013, the Supreme Court decided that you cannot go there. Now, in one of their prayers, they have said that that should be a declaration. But until you seek to overturn that decision of the Supreme Court, you have to make a formal invitation to the Supreme Court to tell the Supreme Court, in 2013, this was your position. Could you relook at this, reset, recalibrate the jurisprudence surrounding spoiled votes? Until that is done, this is a shipwreck, unfortunately. I don't want to cast any aspersions. I am alive to the fact that the sub judice rule plays or comes into play. I'm not commenting on that, but I'm just saying what is placed on the table looks so different from what is propounded. Also, it's a little shocking that Raila Odinga called a press conference and said there has been a hacking of the IEBC. Hacking? What he presented to us showed there was no hacking, because that evidence pointed to a Microsoft-based so-called system. Mm-hmm. When the IEBC said, we don't operate that sort of a system, we have an Oracle-based. Now, he hasn't brought that on board. Secondly, he shifted and said, we have an interference with the voting through what he said, a logarithm, you know? And you wonder, so it is not an external hacker now whom he associated faceless to Jubilee. He now came to say the IEBC has an internal mechanism of propounding Uhuru's votes by 11%. At every stand. So
you're saying this whole shifting of positions could hurt them?
Now wait a minute. Yes, I agree. But let me finish that point. Curiously, he doesn't say that that is a core issue in his petition. Rather, he says, we have about 14,000 polling stations whose Form 34s are questionable because A, allegedly, they were not gazetted. Allegedly. You have returning officers who did not sign some of those Forms 34. Right. I have to remind him, in the Ghanaian petition, those were the same reasons that Mahama faced. They were thrown out.
So in your view, it's more of a quality versus quantity kind of argument.
Yeah. And he missed on the quality.
Okay, so on the flip side of this, what do the respondents need to do to defend their position?
Well, I'm not holding brief for Jubilee. I'm not holding brief for the IEBC. But this, to me, is a walk in the park, as it were, without wishing to cast any aspersions. How do I mean? The IEBC is being told that it had about 11,000 polling stations without presiding officers who had been, as it were, not being gazetted. But the IEBC said, we do not have 3G access of these 11,000 polling stations. That's entirely different from saying they are not gazetted. So eventually the results were transmitted through satellite phones. So what then is wrong with Raila's team in seeing this? I even am more curious when the returning officers are not even sought who would say that, yeah, I was not gazetted and I submitted the results. He doesn't go there. We have only 4 witnesses: himself, Kalonzo, the so-called IT expert, and a BSc holder. Now, you would wonder, the person who should be swearing the primary affidavit is a chief agent, Musalia Mudavadi, or at best, the deputy, Orengo. They don't. So I think, in my view, whoever crafted this suddenly went to the drawing board immediately after the presser that we have to go to the Supreme Court.
Let me bring Sekou into this to get your response on what Harrison is saying.
In terms of... on my part, I reserve, I do not want to prejudge that, because frankly speaking, I have not read the whole of it. It's the 20,000 or so, as people claim it, or whatever. I only read the petition and the affidavit of Raila himself, and whatever. So I want to be, whatever, to reserve judgment on those things, or even necessarily what the court would say. The only thing I say is that for the allegations that they make, they are going to have to prove them.
Right.
Okay? And what they do, as is rightly the case, is that he who asserts proves. So it's one thing to say, I have 5,000 pages of documents, or 20,000, whatever the number is.
Right.
It's another thing for that 5,000 or 20,000 or 1,000 to prove what you're claiming. That's all I can say at this stage.
Okay.
I would not want to try and sit here and pretend to know what the Supreme Court will decide, or what quality of that
and
evidence that would be.
Understandably. So let's look at the 7 Supreme Court judges. A lot of people wondering which way will they go when it comes to this. Of course, we know in 2013 it was unanimous with the 6 justices, but now we have a new Chief Justice in play, and this is probably the biggest case of his life yet, of his career yet. But let's look at least Chief Justice David Maraga. He's the president of the court, presiding judge, a staunch SDA. He'll be the tiebreaker should the other 6 judges tie together. He's practiced law for 25 years. Without being preemptive in all of this, how do you kind of judge his judicial ideology, for instance?
Okay, I know this is something people talk about, but I want to be very honest. Of the Supreme Court judges, the only person I can say whose judicial philosophy I would be most comfortable to say something about are probably Smokin Wanjala and J.B. Ojwang, because those were academics. Let's remember, this idea of judicial ideology is an American thing.
Yes, very much so.
Mostly. And it's often taken from the way American law schools teach law, and the way judges then come into practice for the United States Supreme Court. The United States Supreme Court is a court, but it's more or less of an ideological, intellectual furnace.
Right, conservative
so
or liberal.
you're able to see what those judges are based on the sum total of their experiences. So for Justice Maraga, I would say that from reading his judgments, that's what you can often see. And from reading his judgments, I would not put a specific ideology on him. I would say that he's a results-oriented judge. His approach to cases is, this thing has come before me, what is the law that I should apply to resolve this dispute? That's what I can say. I would not put to him a traditional law school ideological heart on him.
All right, let me bring Harrison in on this. At least of the 7 judges, the ones that you've interacted with, where would you place some of them?
First of all, the Chief Justice issued a directive to the media. When commenting about this case, you shouldn't venture there. All I can say is that they are all professionals. 1. 2, very objective. 3, very dedicated to their work. And so I think in Raila Odinga invoking the judicial process, he believed strongly, or at least his cohorts and his acolytes believed that indeed they would find justice before these judges. Now, having said that, all these judges took the oath of office that is found in the 3rd schedule of the Constitution. And it binds each one of them, and of course severally, as a court, the Supreme Court, to ensure that they render justice without fear, without favor, or without any other external persuasion. I believe that that is what they will do. However, what I am curious is, will Raila and his brigade accept, embrace, and live with a decision unfavorable to them. Let us remember this. These judges will not invent any evidence. They will not bend any evidence. It is what Raila has placed on the table.
Right.
In 2013, his own decision, Raila Odinga versus the IEBC, when the unanimous decision was made, the Supreme Court said, you have to understand the issue of the burden of proof. Sekou has said that. And that burden must initially be discharged by Raila and his team. Raila has the burden of showing that indeed these 14,000 polling stations that he alleges were not gazetted, were not in fact having results within the prescription of the law. He has the burden of proof to show that in fact the Forms 34s, which he claims are inconsistent with what was actually pronounced at the National Tallying Center, indeed do not correspond. And
taking that into account, because timing is going to come into this. They only have 14 days to hear and determine this particular case. In the last petition in 2013, the court rejected AFRICOG's request that the IEBC produce all registers that were used to identify voters at polling stations, citing that they had a limit of time. They only had 7 days to hear the case. When it comes to the massive amount of evidence that NASA has presented and what they have to go through, is that going to be sufficient time? Sekou, I'll go to you then, Harrison.
Let me say before he says, let me finish that as I answer your point. If you look at that petition, which Sekou agrees that he has had a look at, Raila is asking for all the electronic devices that have been used in this presidential election. What are you talking about? All those 49,000 plus EVDs, you want the Supreme Court to sit back and look at each one of them. You want the Supreme Court to look at all those Forms 34 in all those polling stations. Haha. This is an invitation to disaster of your own making.
Let me get your take on that. The timing, is that going to be sufficient?
Okay, timing is there's not going to be sufficient time. I mean, 14 days is quite a stretch of time, which is why, as we are trying to say, the case has to be really snipers. It has to be a sniper's case that is very, very direct, very, very clear, with very, very cogent evidence for a decision to be made for you. If it's something as cloudy as trying to get this 40,000 pages, even for me, as I looked at it, 20,000, if it's even 20,000 pages, to read 20,000 pages in 14 days, you're probably reading something in the region of 1,500 per day.
Right.
That in itself is quite a feat for the judges to get to. And that is only on the NASA side. What happens then when IEBC and the other respondents, then you're talking about this, which is why the design of the Constitution in having this thing resolved within 40 days requires that you challenge it, and you challenge it with something extremely clear, very obvious, that is very quick for the judges to see and to resolve clearly.
Right.
So when you tend to dilate towards such other things, which you're saying, we need to bring these things, I've seen one of their prayers, the orders they're seeking from the court is an audit of that kind of thing, and on the other hand, you are asserting certain things. The court is unlikely to whatever. I think at some point they will be told, what exactly do you want from us? What does your evidence prove, and can it make? Because the test eventually will be, did we have a credible election in compliance with the laws generally or not? Okay. Because that's what has to be answered, in my view.
Yes. Okay, Harrison, as we wrap up, what does this mean also for the IEBC? Even if they come out winning, still their reputation has been damaged. They are under trial once again after 2013. What do they need to do to redeem their image after this petition is all done?
I think weighed against the observer's verdict, the general perception, and I was an observer, was that this election, passed the test. And unfortunately, Raila and his team did not accept that verdict. What is shocking is they had their own eyes on the ground in the name of their agents. Where are those agents' reports? The evidence that we would see. And like I say, let me repeat this. It may sound harsh, but Raila did not call his chief agent, Musalia Mudavadi, as his witness in this case. I'm sorry to say that he carried the whole evidence that would have showed that indeed A, B, or C, or D polling stations had those problems which he claimed. And Sekou has said you cannot generalize in a presidential election, given 14 days. And so let's not try to demonize the IEBC. The IEBC, in my humble view, did everything it could to render a credible election. Why? Raila tried to point out way before, so-and-so is rigging, so-and-so is rigging. So I think the IEBC went to seal all those loopholes. And so Raila is a victim, as it were, of his own so-called engineering in this instance. So he's in an act of self-negation. He's negating his own efficiency, as it were, to ensure the IEBC plugged every hole. And since there was nothing to leak.
And we have to wrap up on that note. And of course, the Supreme Court will be the judge of that. Thank you so much, Harrison Kinyanjui and Sekou Owino, for your insights. Let's take a short break here.